Hey everyone, welcome back to the channel. In today's video, we're diving into a story you'll definitely want to stick around for. This isn't just another update. It's one that adds new layers to a case we've talked about before. A few months ago, I covered a situation involving a self-styled sovereign citizen. At the time, the case raised plenty of questions and sparked strong reactions. Now, new details have surfaced, and they change how this entire story looks.
For the record, I am the beneficiary of the Frank Anthony Michaud Jr. estate. I am the authorized representative, and I appoint you, the judge, as the trustee, ma'am.
Toward the end of that earlier video, Judge Martin made it clear that the next court appearance would take place in front of Judge Oakley. I even mentioned it at the time, and some of you may remember that name right away. Judge Oakley is not new to this channel, and we've discussed his courtroom approach before. He is known for running a tight courtroom and sticking closely to the law and procedure. Arguments that drift away from established legal rules don't usually go very far with him. Because of that, many people expected this next hearing to take a very different turn.
Okay, it's under the barcode, though. This is what you signed up to do. You're a public servant.
Unless you are a price on a can of beans, we don't need a barcode.
Well, today is the moment everyone has been waiting for. Ladies and gentlemen, this hearing delivers one of the most intense courtroom exchanges we've seen, involving a self-proclaimed sovereign citizen. The outcome is striking, and the courtroom dynamic shifts fast once the judge takes control. The judge presiding over this case is one of the most firm, direct, and commanding figures ever featured on this channel. He addresses the arguments head-on, shuts down unfounded claims, and makes the law unmistakably clear. What unfolds is a rare example of a judge firmly correcting misinformation while maintaining full authority of the courtroom. What you're about to hear is unlike anything we've covered before. The response is clear, forceful, and leaves no room for confusion about how the court views these arguments. With that said, let's get into the hearing and see exactly how it all plays out.
All right, appearances for the people versus Frank Michaud Jr.
Good afternoon, Your Honor. Mohammed on behalf of the people, P86771.
No, it's not. You have work. So
Yeah,
you're on Friday.
Are you representing at the desk, representing yourself?
The judge needs to address you, sir. Is that a problem, sir?
Yeah, you're a defendant. Sit at the defendant's chair.
I'm not defendant. I'm sorry.
Judge, if I may try to help explain.
Try.
I'll try. Mr. Michaud is a sovereign citizen, and
No, I object. I'm not a sovereign citizen.
All right, sir, don't speak.
I maybe am not phrasing that correctly.
Don't speak until I ask you to speak.
But there is a difference between Frank Michaud, or I think it is Mr. Michaud's assertion that there is a difference between the natural person, Mr. Frank Michaud, and the sort of legal entity.
I don't recognize that.
And that's what I've prepared Mr. Michaud for that.
Sir, you're a defendant in my courtroom. Either I issue a bench warrant because you haven't appeared, or you come up here and sit in the chair and we proceed.
All right, so you're threatening me to...
Absolutely, I'm threatening you. Either you're here today or you're not. If you're not here today, a bench warrant will issue. If you're here today, I need you in the chair so we can proceed with the proceeding that's scheduled, which is a preliminary exam.
I honestly wish more judges handled their courtrooms the way Judge Oakley does. He moves straight to the facts, wastes no time, and makes expectations clear from the very start. If there were a definition for no nonsense in a dictionary, his photo would fit perfectly beside it. As this video continues, the intensity only keeps building. Each moment raises the stakes, and the exchanges become more dramatic as the hearing unfolds. That be why the time you reach the end, the situation escalates far beyond what anyone would expect.
If I may, I have advised Mr. Michaud that the courts receive objections all the time, or rule objections that are preserved on the record. If he has,
He can appeal me. I'll let you build whatever record you want to build, Mr. Michaud.
Are we on record?
Yes.
Are you on your oath to the Constitution?
Hold on. Are you picking him up? That's one of the reasons I want you up here, is there's a microphone here.
I'll speak loud.
Are you picking him up?
Yes.
Go ahead.
Are you honoring your oath to the Constitution today?
Pardon me?
Are you honoring your oath to the Constitution? You have an oath to the
I didn't swear an oath to the Constitution.
You have
I took an oath that said I would follow the Constitution.
to not uphold the Constitution?
Yes, follow the Constitution.
So you are upholding your oath to the Constitution?
Yes.
Thank you. I accept your oath. Thank you. Okay. Now I have.
Sir, get your ass in the chair or leave and I'll issue a bench warrant. You're not running the courtroom. I am. If you want to have an exam today, get your ass in the chair. That's the way it works.
I reserve all my rights.
I would have nothing less.
I reserve all rights.
Now, are you representing yourself today?
I'm presenting myself.
That's not what I asked you. Are you representing yourself, or is this gentleman going to be your lawyer for today's proceeding?
I will be presenting myself today.
May
All
I?
right, so that's a no. You don't want him to represent you?
No, for the record, he's not my lawyer. I don't have an attorney. I present myself.
Okay.
Judge, what I recommended to Mr. Michaud is that he has a jurisdictional argument that he wants to make. And that, you know, pending Your Honor's ruling on that jurisdictional issue, I have prepared to conduct a preliminary exam.
Okay.
And could be, you know, available if he wanted to ask me to do that at the correct time.
So you want to represent yourself for that jurisdictional argument, and if I rule against you, then perhaps you want him to represent you? Is that what I'm hearing?
No, that's not what you're hearing.
All right, so you don't want him at all under any circumstance?
No, I don't need an attorney for the record.
I don't think anyone needs additional proof to see that the decisions being made here are deeply questionable. It's hard to understand the logic behind choosing self-representation in a serious criminal case, especially when the stakes are so high. That choice alone raises concerns about judgment and awareness of the legal process. What makes it even more puzzling is the fact that a qualified legal professional is standing right there, fully prepared to help. That attorney has spent years studying the law, learning courtroom procedure, and handling cases like this professionally. Ignoring that level of experience in favor of personal theories rarely ends well in a real courtroom.
Okay.
So, with that being said,
well, hold on. You can stick around if you want to, but I'm not going to obligate you to stay.
I understand, Judge. I'm definitely going to stay.
That's fine. All right.
So, today,
you have a jurisdictional argument you want to make?
Well, I served notice.
Sir, it's a yes or no. Do you have a jurisdictional argument you'd like to make today?
I have a
yes or no.
Why are you forcing me to say answer?
Because I'm running the courtroom and it's the way I want to do it. Do you have a jurisdictional argument you'd like to make today?
I do, yes.
Then make it. What's your jurisdictional
argument? I'm presenting myself. So I need to know, Article 6 of the Constitution grants me the right to know what jurisdiction is this court operating up under?
State of Michigan.
No, what jurisdiction?
State of Michigan.
Okay, what jurisdiction is the state of
District
Michigan?
courts are legislative courts. That means they're created by statute. The state of Michigan gives me my jurisdiction.
So, okay, is that
I work under the authority of the state of Michigan.
What is it? Under what jurisdiction? There's two different jurisdictions under the Constitution. You have admiralty and common law. So I'll need to know.
This is not admiralty.
What is it?
And it's not common law. It's statutory.
Okay, so it's statutory. That is what, civil?
No.
So what is it?
My jurisdiction is both civil.
I can't defend myself unless I have it on the record.
From a practical standpoint, representing yourself is never a wise move if you don't clearly understand how the legal system actually works. Courts operate on specific statutes and established procedures, not personal interpretations or internet theories. Confusing different areas of law only makes things worse once the case is underway. There's a major difference between concepts like common law, maritime law, and statutory law, and they are not interchangeable. Mixing them together in a criminal courtroom shows a serious misunderstanding of how cases are decided. That lack of clarity often puts defendants at a major disadvantage before the hearing even begins.
Is it
my jurisdiction?
It's only two.
Sure, shut up. If you ask me a question, I can't answer while you're talking.
Okay, cool.
My jurisdiction is both civil and criminal as provided by the statutes of the state of Michigan.
Okay, so today, under which one is
this? Is a criminal case.
Okay, right. So is that common law or admiralty?
It's statute. It's neither common law or admiralty.
It's one or the other. It don't say statute.
All right, then you can appeal my ruling. My ruling is it's neither admiralty or common law.
So this is you say it's criminal for the record?
Yes.
Okay, and if it's criminal, in order for a crime to exist, there must be an injured party for the record, right?
There must be what?
An injured party.
Yeah, it's the people of the state of Michigan.
All right, so if the people of the state of Michigan, right, where's this sworn statement
Where's what?
A sworn statement. I have a right to see a sworn statement saying I injured someone.
There's a complaint in the file.
Sworn complaint, signed,
You want to see it?
affidavit, sworn affidavit.
No, it's not. I don't think it's an affidavit.
Well, okay, so
You said you wanted a sworn complaint.
from an injured party, who have I injured for the record?
The state of Michigan
How can I
are
injure
bringing
the
the
state?
charges.
How can I injure the state?
Sir, sit down. Sit
I prefer to stand.
down.
I'm not.
Sit down, or I will hold you in contempt.
Another threat. Wow.
You're probably going to hear more than one.
I see.
But when you really look at it, what's happening here is pretty clear. You see a judge who has clearly reached the end of his patience after dealing with constant interruptions and pointless arguments. The courtroom atmosphere reflects frustration built up over repeated refusals to follow simple instructions. At this point, the consequences become unavoidable. The individual's refusal to cooperate, remain seated, or follow courtroom rules starts to carry real legal weight. Instead of helping their own situation, their behavior only pushes them closer to facing time behind bars.
All right. I am ruling that I have jurisdiction. You are free to appeal that to the circuit court. Proceed. Do the people have a witness they'd like to call in the exam?
Yes, Judge, the people are prepared to move forward. Just as a quick preliminary matter, we'd request a mutual order of sequestration with an exception for the
So-
OIC.
All right.
So again,
I'm not asking you to talk. Ma'am, are you a possible witness in this case? Okay. All right. And would you mind putting your name on the record, please? Counsel, I want to look at the lady. Would you mind putting your name on the record?
she's a witness. She is a witness.
Sir, you speak again when I haven't asked you to, and you're in contempt. And we'll deal with that first. The reason I need your name is because if you appear somewhere down the road and want to testify, we have to know that today you were in the courtroom. And I can't do that by taking a picture of you. So I'm asking you to state your name.
Your witness. Yes.
Sir, you are in contempt of court. That's a $100 fine. Speak again when it's not your turn, and I'll continue to up the ante. Clear? You can speak now. I've asked you a question.
I object.
I don't give a shit if you object. Is it clear what I said? I'm waiting for an answer.
I said I object. What am I supposed to say?
I want to know if you understand you've just been fined $100 for contempt.
I don't understand.
Okay, well, you still owe me $100.
Let's take a moment to recognize judges like Judge Oakley, who bring experience, clarity, and firm leadership into the courtroom. Judges like him play an important role in keeping proceedings focused, lawful, and respectful. They ensure that rules are followed and that justice isn't derailed by distractions or misinformation. His approach makes it clear that the courtroom is a place for facts, law, and accountability. That'd be why addressing disruptive behavior directly. He helps people understand the real consequences of their actions. That kind of professionalism and decisiveness deserves acknowledgement and respect.
Are you going to give me your name? That's fine. Thank you. Witness.
Your Honor, the people call Officer Steppen. Oh, I'm sorry. One last quick preliminary matter. Pursuant to 76611D, we'd like to introduce a certified registered of action in regard to this individual being a previously convicted felon.
I object.
Hold on. Have you showed that to him?
I object. I object.
What's your objection, Mr. Michaud?
My objection is that I am here under the guise of
Bless you.
probable cause conference. And I don't know how we're here at a preliminary exam when I did not waive any right to waive a probable cause.
This is a preliminary exam.
This is, okay, so right here.
This is the probable cause hearing.
It says, it's.
All right,
it
stop,
says-
stop. Right now, the question on the table is, you've objected to admittance of that document. I want to know what your legal objection is.
I'm also objecting.
What is your legal objection?
To not waiving my probable cause hearing.
Denied. That's admitted.
Under what grounds am I denied not?
Because you
have my due
didn't give me a
process?
valid objection.
I object.
You can't just object. You got to explain with the valid
I
objections to the
object
evidence.
that we are having a preliminary exam when I haven't had a probable cause hearing that I did not.
They're the same thing,
It's
Mr.
still,
Michaud.
on this.
Mr. Michaud, they're the same thing.
But it's still, I have a right to a probable cause. Am I right or wrong?
Sure, try.
Am I right? Do I have a right to a probable cause?
That's what today is scheduled for.
But today it says preliminary exam. Right here it says probable cause conference, and today is a different date that says a preliminary.
Have you ever had a grilled cheese?
If it was different.
Have you ever had a grilled cheese?
If it was different, why would it have two separate
Have you ever
columns?
had a grilled cheese?
I object to any of that. Why would it have two separate columns?
Take him out.
Why would it have two separate columns?
I'm not playing this game with him today. If you think you can get him to shut up long enough so we can have our hearing, we'll do it. But I'm not going to let him try to run my courtroom.
Okay, I'll just be very brief in my one attempt here. I would like to try to explain what I understand Mr. Michaud's objection to be, and what I have also represented to him regarding that objection. Mr. Michaud, I think the court record will reflect, had a probable cause conference first on November 29th, and then again on December 20th. I have disclosed, I mean, I think I've been very transparent with Mr. Michaud that probable cause conference is a bit of a misleading name, because probable cause conference under the court rules does not require that probable cause be established.
Right.
At the second probable cause conference, Mr. Michaud was caring for a sick relative, so he wasn't able to attend that probable cause conference scheduled December 20th.
Which didn't hurt him at all.
Right. I represented him on that day, and I asked the court to waive his appearance so that he could remain with his family.
Which we did.
Understood to be his wishes. I may now understand differently that I misrepresented him in some way, but my goal was just to be able to conduct a probable cause conference where we were going to find out if there was any offer, whether discovery.
You don't have to tell me what they are. I know what they are.
I know, but I'm just trying to explain.
And I'm trying to explain it to him too, but I'm not going to talk over him.
Right.
And I'm not going to play that crap today.
Right.
So if you want me to explain what's scheduled today versus what was scheduled last time, I'm happy to do that. But you got to be quiet while I'm talking. Clear?
Oh, dude, I hear you.
All right. The last court date that we call a probable cause conference is like a pretrial on a misdemeanor. It gives the parties a chance to discuss the case and see if there's any resolutions prior to the next step. Next step being preliminary exam. At the preliminary exam, the people have to prove to me that there's probable cause to believe that there was a crime and there's reason to believe you were involved. That's what's scheduled today. That is a probable cause hearing. Probable cause conference is just a name that we all came up with instead of saying it's a pretrial for a felony. Do you have any questions based on that?
At what point did I waive it?
At this point, it feels like we're watching someone who simply refuses to process what's being explained to them. If they would pause and actually listen to the judge, the situation would make much more sense. The confusion here isn't coming from the court. It's coming from a lack of understanding that a probable cause conference is, at its core, a procedural meeting where discussion takes place, that it's meant to organize issues, clarify next steps, and keep the case moving forward. That IT is not the same thing as a full probable cause hearing. The probable cause hearing, the one being complained about, is what's actually happening today. That means nothing has been waived or taken away improperly, despite the claims being made. The court is following standard procedure, step by step, exactly as the law requires. Situations like this highlight why courtroom instructions matter so much. When someone ignores clear explanations and replaces them with assumptions, it only creates more problems. Understanding the process could prevent a lot of unnecessary conflict and frustration for everyone involved.
Because if it's a hearing, or
You
a conference,
didn't
right,
waive it.
so I
There's
have-
nothing
so
to
do
hold.
I have a right to have a probable cause conference?
No,
What?
you can do that right now. Do you want to make a deal with the people?
I want to be able to prepare myself for the probable cause conference. And in order
There's
to
no
prepare,
preparing for a probable cause
It's-
conference.
it's-
It's a conversation.
It still takes preparation.
You want a PCC? Go out in the hallway, have a PCC with the unrepresented defendant.
Judge, just for the record, there will be no offer at this stage.
There's your PCC. Now, do you want to plead guilty? Do you want to have an exam? And at the exam, he's got to prove to me those two things I just said. Probable cause to believe a crime was committed on this date and reason to believe that you were involved. Do you want to have that hearing so he has to prove his case? Or do you want to waive? That's the other option. You can waive the preliminary exam and we'll take the case directly to circuit court level 2 weeks down the road for an arraignment on information, which I would describe as another pretrial on a felony, where you and the prosecutor can discuss the case, see if there are any offers. That's another option. Would you agree with that assessment, Mr. Sullivan?
I would agree, and I would also just add that Mr. Michaud has made his arguments today, he ruled on his arguments, and that he preserves his right to—
He can appeal them.
as you've already said, at circuit court. And so if he wants to sort of move forward on that defense alone, that, you know, the waiver does not preclude him from
not at all
arguing jurisdiction at the circuit court level. But likewise, if he holds a preliminary exam today, holds the people to their burden, he also maintains the right to, you know, continue his objections to jurisdiction, to appeal the court's orders regarding jurisdiction at that next level, at the circuit court level, assuming that the people are able to prove probable cause today.
Now, do you want to have an exam today?
Well, I wanted to address some, I served the court some notices.
I haven't read any of that because you were represented by counsel.
No, I wasn't. I don't have any contract.
As far as I knew, you were represented by counsel.
Okay, so now you know. And I served the court notices. And I would like to—
First notice, what would you like to put me on notice about?
Well, I served you notice that I requested the criminal bonding information. I requested
Criminal what?
bid bond.
Hold on.
I requested the bid bond, the performance bond. I have an affidavit.
There is no bond.
There are bonds. This is
okay, listen. You can't tell me something and then just disagree with me and think listen to me, sir. I am not going to let you interrupt me.
Oh, you just interrupt me.
I'm in charge. I get to do shit you don't get to do. It's part of the black robe. Okay, that's just the way it works. My courtroom, I get to decide how it's run.
If it truly meant nothing, then there would be no reason to follow the judge's instructions at all. The fact that compliance happens tells a very different story. But IT suggests there is an understanding, whether admitted or not, of who holds authority in that courtroom. Courts don't operate on personal beliefs or selective agreement. Orders are followed because they are lawful and carry real consequences if ignored at some level. That reality is understood, even when someone argues loudly against it.
There are no bonds required for me to do what's scheduled today. I've been doing this 25 years. I've never had a bond.
You have a bond.
Okay, I have a bond.
Everyone here has a bond.
Not in any definition I know. So let's get to the point. Do you want an exam today?
No, I really want to address. Okay, so
I'm not addressing any of that crap you got in front of you.
Well, since you say you don't have a bond, can you express that in a via affidavit so I can have a?
It's on the record. Order a transcript. I'm not signing anything for you.
Okay. Also, I want to also address that. I sent a affidavit of fee schedules for violation of any of my rights.
There are no fee schedules.
Well, I gave you notice, and
great. Then you gave me notice. Doesn't change anything. We still scheduled for an exam today.
Yes, just put it on the record that I served you notice. Okay. Also, I served you notice on my power of attorney.
Okay, you said that.
Right, and
move on.
You haven't responded to that, as well as my indemnity bond, which separates me, and I have a private capacity. I am not the artificial person.
I don't recognize any of that.
United States citizen. I am actually
hold on, stop. You can put on notice what you sent the court if you want to make a record of that. But I'm telling you, I don't recognize any of that stuff you're talking about. I don't recognize that you're not really Frank Michaud. Okay, I understand that's what you're trying to argue, but I don't recognize that.
Under what law could you represent, or you can use, tell me that, not just from what you say, because ignorance of the law is no excuse for you or nobody else. So what you're saying just don't mean nothing. I need to have facts.
Okay, well, it does mean, hold on. It should mean something because.
Prove it, please prove it.
Can I prove what?
Prove that I am not that I am the artificial person.
I can prove you're Frank Michaud.
I have full faith and credit.
I can prove.
Okay, so
hold on. You've asked me. I can prove you're Frank Michaud. You know how I can prove that? Because when I called the case and said you either come up here and be Frank Michaud or you leave, you came up here. And you proved it for me.
You threatened me.
But if you're not you, the threat means nothing.
It doesn't mean nothing.
This is basically the moment where fantasy collides head-on with reality, and the stakes couldn't be higher. That on one side, you have delusions, perfect for imagining impossible scenarios, like unicorns with rainbow trails. On the other side, there's reality, which deals in facts, rules, and consequences. And in this case, it's very clear what reality delivers for self-proclaimed sovereign citizens. Reality often means serious legal repercussions, and it doesn't lose. Every attempt to ignore the law or twist it in your favor meets the hard, unyielding truth of the courtroom. This showdown isn't a debate. It's the law asserting itself, and it wins every single time. As we near the close of today's coverage, it's worth noting that the judge still had a few powerful statements to make. Even at the very end, his words reinforced the seriousness of the proceedings and the importance of following proper legal process. Those final remarks leave no doubt about how the court views these claims and behaviors.
But
Okay.
you're still threatening me, and you're using it under color of law.
Okay, listen.
And plus,
Listen
you
to
have,
me. Mr.
you
Michaud,
have, you have
I've
multiple
wasted
officers.
too much time with you. Yes or
Okay.
no?
So,
Sir, don't argue with me. Yes or no? Are we doing a preliminary exam today? Yes or no?
I object. I will address.
Answer the question.
I want to address other issues as well.
You're in contempt of court. Put him in jail.
For what?
For contempt of court.
I'm having.
You can appeal that too. Sentence is 30 days. See you in 30 days.
All right, everyone. That wraps up the main part of today's video. But don't think this is the end of the story. There's still more to come. Because of his disruptive and contemptuous behavior, the probable cause hearing couldn't be completed today. That means we can expect at least one more special appearance in front of Judge Oakley. That it's also likely that future hearings in front of the circuit court judge will continue to draw attention. This case is far from over, and we'll be following every twist and turn. That if you enjoyed the video, make sure to hit that like button. That if it wasn't your cup of tea, feel free to hit dislike. But please leave a comment sharing your thoughts. Don't forget to subscribe and turn on notifications so you never miss new updates. I'm Team Skeptic, and I'll catch you in the next one. Music, here we go.
I object to that. That's
I'm happy to hear your objection.
Due process.
Appeal me. That's why circuit court judges have jobs.
Definitely.
Take him out of here.
Under color of law.
I can give you more than 30 days. John, ask the wife to come in so he can see his property go to his wife. Ma'am, would you accept some personal property from your husband, please?
That was an extreme amount of patience.
Good try.
I appreciate you, giving him as much latitude as you did.
I just can't let him run things. I'll let him engage me and, I don't mind that, but I just can't let him try to run things.
Yeah. No.
Especially when I got 3 or 4 more exams to do.
Right.
The internet is the worst thing in the world for these guys.
I tried to tell him.
It don't play here.
The court is going to deny your objection. Let's allow this to move forward. He might have been able to win this.
And that's the worst part about all these cases, right?
Yeah.
Because sometimes they've got a chance if they just,
We had a good
Ron White,
argument.
Ron White, right?
Yeah.
Got a constitutional right to remain silent, just can't do it.